Hello, everyone. Thank you for joining us today. I'm leaving a couple of minutes for all the people to join. I see participants joining. I guess it takes some time. All right. Thank you for joining us today. And I'd like to say a few words about the Washington Foreign Law Society to start with. My name is Alexandra Boshnikova, and I'm the president of the Washington Foreign Law Society. The Washington Foreign Law Society is a nonprofit educational organization based in Washington, D.C., that for the last over 70 years is working on promoting the knowledge and understanding of international and foreign law and international relations. We organize online and in-person events almost on monthly basis, but sometimes more often. And I encourage you to go on our website and subscribe to the newsletter and become a member because it will give you access to a series of very, very interesting events. And I just want to share with you a very exciting news. Save the date, October 16th at the University Club. We're having our annual gala. And with a very special guest coming from Vienna. Um, we are honoring Raffaello Mariano Grossi, who is the Director General of the International Atomic Energy Agency. He's joining us. It's going to be an amazing evening where you can mingle and meet new people and people from the energy sector, but not only. I also encourage you to join us for the state sovereign state arbitration event that will take place in November. Also, an in-person event. We are also currently preparing our embassy roundtable event, which will usually takes place in December, where you're invited by one ambassador to learn more about the country and the embassy. Last week, we had the chance to be invited by the Spanish ambassador at her residence, sorry. And in parallel, we're organizing U.S. State Gala that takes place at the Benjamin Franklin Room at the U.S. State Department. That have been a friend and member of the board of the Washington Foreign Law Society for a long, long time. It's going to be an event honoring a country. Last year it was Ukraine. So please keep posted. We have many, many other events in the cooking. So stay posted, subscribe to our letter and become a member and follow us in order to participate to these events. So one of these events are the AI series, the experts talk, and our conversation today is the fifth gathering, part of this series, that we organize to learn more, to stay up to date, to stay ahead of our time. And we're talking with experts in the field about the implications of AI. We're trying to anticipate the implications on the legal profession, but not only. And we're organizing this event with a very long-term and very supportive friend of the Washington Foreign Law Society, which is the Stimson Center. And I will give the floor to Kathryn to talk about the Stimson Center and to introduce our speakers. Kathryn, the floor is yours.
Thank you so much. Good afternoon and the warmest of welcomes. I'm Kathryn Rauhut, and I'm honored to introduce today's webinar, co-hosted by the Stimson Center and the Washington Foreign Law Society. As Alexandra mentioned, our two organizations have partnered together since 2021 to explore emerging technologies from cyber accountability to artificial intelligence, and to share insights through conversations like this one. Today's program, One Size Does Not Fit All, Examining Approaches to AI Policy, could not be more timely. Governments around the world are moving forward quickly with very different models of AI regulation. Europe has already adopted a sweeping AI Act. Italy has developed its own comprehensive laws. And meanwhile, here in the US, we're seeing fragmentation. States are advancing their own frameworks while a coherent federal approach is still uncertain. For international companies, these raise real questions about compliance across jurisdiction and whether a patchwork of rules will leave gaps. Even when the rules exist, there's another major challenge, which is accountability. If an AI system causes harm, who is responsible? Is it the developer? Is it the business that deployed it? Or is it the end user? The frameworks that we develop now will answer these questions for years into the future. So it's incredibly important to develop the governance structure in a very sound and practical way. At the Stimson Center, our mission is to find practical solutions to global challenges like these, and AI is certainly one of the most complex and consequential of our time. Stimson's AI focus is on analyzing the technology's impacts on international security, foreign policy, and global developments. The way governments choose to regulate or not regulate AI will affect how its benefits and risks are distributed and who is included or excluded from those benefits. We are fortunate today to have three distinguished experts who bring global, legal, and technical perspectives. Sophia Oberschelp de Meneses is the special counsel at Covington with deep expertise on the European AI Act and AI compliance. Giulia Neaher, a research analyst at Stimson's Strategic Foresight Hub, is leading projects on AI policy and responsible AI in the Global South. And Christabel Randolph is the associate director at the Center for AI and Digital Policy. She oversees US AI law and policy and brings extensive international governance experience from over the last 10 years. And with that, let's get started.
Thank you so much, Kathryn, and huge thanks to our panelists today, and to Sophia, who is joining us from Brussels. And huge thanks to Momin, who supported the organization of this webinar and make it possible. I want to start with a very basic question, because since lately in the US, but not only, there is a very heated debate between partisans of legal framework, some framework to harness AI, and the opposite forces that are against any regulation that is perceived as a constraint to win the competition of AI, the AI race. And therefore, I want to start with one very basic but paramount question. Let's recollect, why do you need to regulate? What is your view about why do we need to set the framework for AI? Who wants to take the floor, ladies, first?
I'm happy to take the floor in the sense that I can start with my EU perspective, because I'm a lawyer here in Europe, and so whatever I'm saying will be obviously biased. So I want to say that from the start. But so from the perspective, from my personal perspective, and from what I read here in Europe, is that, well, the EU AI Act makes sense to Europeans because it proactively addresses the risks that certain AI systems pose. Those risks are risks to safety, to fundamental rights, and societal fairness generally. And if I can be very candid, in the EU, we really foster trust from people through regulation. So it's common to regulate on something in order to foster the trust of the people. People will feel more secure if there's a regulation about something. So the purpose is really to establish clear, risk-based legal framework that ensures that AI systems used in the EU are safe, transparent, non-discriminatory, and human-centered. That way, Europeans trust AI and also think they can benefit from AI technologies. So that's the whole purpose of regulation. And this is not unique in AI. Like we in Europe have done this with many other areas, right? I mean, another area I practice in is GDPR, so data protection. It's also another area where, you know, regulating was important to foster trust in the processing of personal data. And also another very important area, which is very related to AI, at least here in Europe, is product safety. So there are very many rules in Europe on ensuring that whatever products are sold here in Europe, they are safe for the individuals. And when I refer to products, well, this law on product safety, the main law on product safety, has been amended very recently, last year, to also encompass software. So there has been really a movement in like making sure that whatever laws on product safety we have here in Europe, they also encompass like digital products. Services may potentially also, although the product safety law does not cover services, but there's also a whole lot of regulation on ensuring that services are safe. And one example of this is the Digital Service Act. So I could enumerate the number of EU laws that were adopted in the past, I would say maybe 5 years, a bit longer for some of them, but the core of it is making sure that Europeans trust service products that are sold in the EU. And that's one main purpose, and I guess it's a great one main purpose. Then a second purpose being, and what we call, at least from a GDPR perspective, the Brussels effect, which is the EU wants to impose like a standard of safety. It wants to be the first to regulate, to impose a standard here in Europe, but also for anyone that's wanting to operate in Europe. Even if they're outside the EU, if they want to sell something into Europe, they have to comply with the standard that the European Union imposes. And by setting the standard, what we usually call the golden standard, it wants to have an influence in the global economy. Whether it can do that, it will depend, obviously, on how strong it is in the different areas. But it really did achieve that with regards to the GDPR. And probably the reason why it is regulating the AI so quickly, wanting to be the first and regulating that way, is because it also wants to do the same with regards to AI. There's obviously a lot of discussion on whether that happens, but I want to give the floor to my fellow panelists before I enter any of those discussions.
Thank you, Anna Sophia. We'll have time to enter in the topic. I just want to, and I'm sorry for interrupting you ladies, I just want to mention two things. First of all, we received a lot of pre-submitted questions that we tried to integrate in our discussion today. But in case you have new questions, or in case we didn't answer your specific question, please submit your question in the Q&A section you all see on your screen. And I also wanted to mention that we will put in the chat link to our newsletter. And also, why not, Giulia? I know that you're talking tomorrow and you have another similar webinar that might be of interest to our attendance today. And if I may insist, you also had a very interesting paper that I learned a lot from your paper that was published on the, it's more of an article, right? That was published on the Stimson Center. Maybe we can put the link on the chat as well. And with this, I give you the floor.
Well, I'm happy to jump in a little bit just on the question of regulation. I think, Sophia, you made a great case for why regulation is needed in general in terms of fairness and safety and all of that great stuff. I think that you also framed the EU perspective very well. I'll say a little bit from the American perspective. Obviously, there's kind of an appetite for deregulation that's coming out of the federal government right now. I do think that at the same time, the point that you made about public trust is definitely relevant in the US as well. I know that Pew came out with a study basically showing that the majority of American citizens are afraid that the government isn't going to do enough about AI. So I definitely think that there's still a similar appetite in the US. It's just kind of being approached differently. I think at the same time, there are some US specific considerations for AI regulation and why it's needed. I think that the argument that you're seeing a lot right now, and that was kind of accompanying the AI moratorium conversation, was that we need to have kind of a unified approach across the US to make it easier for businesses to operate across states. I think that that is a reason for that is being cited for comprehensive regulation. It's not necessarily a reason for regulation in and of itself, but definitely streamlining it from a business perspective is an argument that a lot of people are making. And then the other piece that I think I would mention is just that, of course, with the new priority on exporting the US AI stack, there are a lot of implications there for what that AI stack contains in terms of safety and fairness and protections and that kind of thing. And so the extent to which policymakers in the US are thinking about AI safety is really going to matter for the export of those products internationally. But I'll stop there.
I just wanted to jump in and add, I think when we're talking about technology regulation, it's also important to remember that there are already existing laws that apply to AI products, to software. So number one, there's not a vacuum. And I think for whether we're practitioners, legal, policy, business people, it's important to remember what is already on the books and what businesses have to adhere to. The other perspective that takes up a lot of space and media and conversations is this AI sort of global AI race conversation, and whether regulation is going to help that or not. But for example, especially in the US, we see a lot of the US versus China AI race debate. China has had AI regulations, binding AI regulations since 2023. So even before the EU AI Act went into effect. We see India this year introduce its AI governance framework. And again, a governance framework might not be binding legislation the way we understand EU AI Act, but it definitely lays out a path as to how existing regulations are going to be enforced and how new regulations are going to be developed. So looking at risks, looking at life cycles, we see the ASEAN AI Guide, we see the Gulf region, the Saudi AI principles. Oman has just opened its consultation. Qatar, UAE have already enacted a lot of cybersecurity regulations specific to AI. So I think the first thing to do is abandon the false choice between innovation and regulation. I think regulation has been happening. Regulation is on the books. I think what we need to see is how it's being enforced. How do the current and future regulatory tools are used to produce optimal market outcomes, as well as social utility and protect public interest.
Yeah, thank you, Christabel. And that's the perfect segue to our next question. And you started already talk about an overview of existing regulations, exactly. And you already mentioned some of them, but maybe we could dig into a bit more into the EU Act that is most of a cover-it-all approach, and then maybe dissect the US action plan and see what is in it, and before we explore other alternative approaches as well. Anna Sophia, you want to start? Yeah.
Yes. Thank you. Yeah, I completely agree with what Christabel said. There's a lot of regulation already, even in the EU. Whether the AI Act is absolutely necessary, well, it's being questioned right now as we speak. The EU definitely thought that there were reasons to have specific laws on AI, and if you read it, the laws go further than what we had already in place with regards to product safety. Includes like the AI, for example, includes provisions on AI literacy, provisions on like if you use AI in the employment space, you have to consult work councils, provisions on like what's absolutely prohibited because the risks to society are too high. Also transparency, what needs to be done on transparency. And I assume that the one reason for this is like what I mentioned ago. So legal certainty, obviously, is being one consideration for doing it, but also the second, this Brussels effect. And then thirdly, if you actually read the law, there are many hints to a bit of a protectionist regime towards the EU's development of AI, because if you have attended conferences in Europe recently on AI, you'll notice that even public officers often say, well, we are really behind on the race of AI, we being the EU. They acknowledge it openly, talk about investment, EU investment being much lower than investment otherwise in other countries, jurisdictions, let's say regions, more correctly regions. And the EU Act has some provisions like guidelines and funding specific for small and medium companies. Well, obviously the small and medium companies will be like European companies that are developing AI. So there was also, I think, a protectionist interest in having the AI Act, the regulation, and which also motivated that law. But the whole discussion on like, whether it's necessary, whether that's really very timely right now, because, and I want to conclude with this, is like, I would like to let the audience know that the EU Act, most provisions of the EU Act have not started applying yet. So some provisions, like the ones on prohibited AI systems, have started applying in February this year. These are provisions that say certain AI systems, if used, are absolutely prohibited because they would be too big of a risk for individuals, for their fundamental rights, principally. And these include, for example, using it for social scoring or certain uses of remote biometric identification. Those are in place, and they're not controversial in a sense that, I mean, no one is discussing it. It's like, okay, it's prohibited. Well, in a sense, it makes sense why they're prohibited, and there's not much discussion on it. But the provisions, a lot of other provisions still have to apply. In particular, the provisions on general purpose AI, so AI that generates content. Those provisions, even though they started applying already, they can only be enforced as of next year, August. So there's still some time, right? People are still looking at it. And then the main provisions, which is the majority of the provisions of the AI Act, relate to high-risk AI systems. And these are AI systems used for specific cases, or AI systems that are specific products or services. Those are very sectorial in a way, because many of these products and services, they are already regulated by EU laws. And those provisions only start applying in 2027. So there's still 2 years for it to apply. And that's why the discussion on whether the EU AI Act and those provisions are necessary is so timely right now. And that's why you see politicians asking themselves, should we delay it? Should we stop it altogether? Should we amend it? So I wanted to bring this on in our conversation very early on, but I want to now give the word obviously to my colleagues on their perspectives.
I'm happy to chat a
Christabel
little bit.
or Giulia,
Oh,
go
no,
ahead.
yeah.
Yeah. No,
I'm
go
happy to
ahead,
chat a
please.
little bit about the US kind of perspective and the way that that has taken shape. I think that obviously with the Trump administration, there's been a significant emphasis, like I said before, on deregulation that we saw with the AI action plan that came out this summer. And it had 3 pillars largely centered on, I think, innovation, infrastructure, and then kind of exporting the AI stack and enhancing America's engagement more broadly with the rest of the world on AI. So I think what's important to note, however, about the American approach is that it is still structurally pretty similar to that of previous administrations in that most of what was said in the AI action plan are kind of voluntary strategic statements that are being made by the government about where they would like to see us go. And in the US, we still have little to no binding federal regulation of the AI industry as a whole. That's why there was such kind of an explosion of conversation about state AI laws and the moratorium that was proposed in the Big Beautiful Bill over the summer, which basically suggested that in order to kind of flatten the AI ecosystem across the US and make it easier for businesses to operate between different states, we should pause all of the various AI restrictions and regulations that are being enacted that are actually kind of binding laws that would apply to AI developers and AI companies and that kind of thing from state to state. That moratorium obviously didn't pass, but I think that rhetoric around easing access and interoperability for businesses is still very much in play. At the same time, I also think that states have really doubled down on their interest in passing AI-related regulations. I think that we're still seeing a significant amount of activity in the states on what they want to do for AI policy. And so I think that my general take on the US approach right now would be that we're still unlikely to see, I think, obviously increasingly now with the deregulatory push, we're still unlikely to see a federal top-down AI regulation in, the likeness of the AI Act. At the same time, I think that the thing that we need to look at is the extent to which these jurisdictional or state AI policies are going to be allowed to continue and kind of maintain that fragmented approach that we have in the US. And that's actually the piece that I sent that I think Momin sent out to the group kind of talks a little bit about that, about how, the comprehensive approach to AI policy isn't necessarily feasible in the US as it currently stands, but that doesn't mean that we can't think about ways to make the kind of patchwork that we have work for us in the time being. But I'll pause there.
Yeah, exactly. And Christabel, you already mentioned that there are many existing regulations, but it's a patchwork. And also AI is not one AI, it's not one technology. There are so many unanticipated use and technology. So how do we reconcile innovation and safety? And do we even have so I have so many questions, so I'm gonna let you answer. But basically, I have 2 main questions out of this. First of all, how do we reconcile innovation and safety with only the existing regulations that don't anticipate everything? And second, do we even have the necessary knowledge, among legislators or agencies or whomever will be regulating, AI? Because I feel like everything is going so fast, so quickly. Do we even something goes out and it's already outdated? There is like a innovation every day on everyday basis. So yes, I'm sorry, I'm gonna give you the floor.
Yeah, so with the US has historically had more of an enforcement approach rather than an ex-ante regulation approach that we see in the EU. And that's not just specific to AI. We see that across industries, even if you talk about financial services or cybersecurity or data protection. So the first thing to remember is the fact that there might not be a uniform framework is a conscious policy cultural choice in the US. And it has worked for the US because admittedly, the economy has grown. there has been innovation. So the patchwork argument is used a lot by industries and tech companies, because obviously if there's if you don't have to comply, your life is easier for you as a business. But the fact of the matter is, if we look across sectors, that has never been really a problem. Even though the US doesn't have a federal privacy law, for example, California has a very comprehensive privacy law, which mirrors the GDPR in many respects. But if you look at the most innovative companies in the world, they're all based in Silicon Valley. They all comply with California's laws, and they're all profitable, right? So that's the first response that I have to the innovation versus regulation, and also as far as the patchwork is concerned. Secondly, with regards to existing laws, I mean, if you look at consumer protection, if you look at fraud, it's the same. It doesn't matter if you're doing it in a person-to-person contact, or if you're using an AI avatar, or if you're using a voice cloning technology, or if you're using a phishing scheme. It is still a fraud. It is still deception. If you're getting in a business room together and you're all deciding to price fix and collude in the market, that's a problem if you're not doing that. But if instead you're using your algorithms, or you're designing your algorithms to price in the same manner, it is still collusion. It is still a violation of antitrust laws. So I think the agility that we see, not just from regulators in the EU or in the US, but I think everywhere, we're also seeing policy innovation as well, both in terms of what really are the guardrails we need from a development and design perspective of these more advanced AI systems, where the whole transparency frameworks and all of that come into play. But we're also seeing a lot of agility in terms of how do you enforce existing regulations. The Federal Trade Commission in the US has opened a study on the 7 largest tech companies to see how chatbots are actually having increased risks and harms to children's safety. In 2023, we from the Center of AI and Digital Policy filed a consumer protection complaint with the Federal Trade Commission with regard to OpenAI and ChatGPT. In 2023, we filed it in March. In July, the Federal Trade Commission opened an investigation into ChatGPT and OpenAI with regard to its data practices, privacy practices, training of data sets, issued a long civil investigative demand. All of this, even though there is no comprehensive AI law. Does EU's approach offer a benefit in terms of having a unified framework, having certainty? Of course. But does that mean that what I think the main point I'm trying to drive home is the absence of a unified framework should not be an excuse for inaction, whether it's about creating the right incentives for innovation, or whether it's about addressing risks and harms through enforcement.
Well, thank you very much. It's all very reassuring what you're saying. Anna, you mentioned that how is the situation in EU? Do we have any feedback on the enforcement of the AI Act or not yet? Or maybe by by existing laws in cybersecurity, data privacy that are applicable to all AI innovations? Do we have some feedback?
Yes, so what Christabel said about other EU laws applying and serving as safeguards for the use of AI, as AI is any other technology, and this is completely my understanding too, and that's what business really should understand when they come and ask for advice on the EU AI Act. Generally, they would say, well, it's true, the AI Act doesn't apply yet, but there are all these other laws that already apply. Yeah? So if you're using personal data, look at this. If your product leads to, even if it's software, leads to has defects and leads to damages, look, there's a new product safety, product liability law. If your product is regulated because it is considered to be, higher risk, look, there are already laws on it. So we do remind people, businesses usually, that there are so many other laws that should be taken into account. And there are lots of investigations also going on in the EU into the use of AI. I don't want to name any specific companies, but we have seen them, and there's not only data protection investigations by now very much sophisticated data protection authorities that have AI departments and really are staffing themselves with AI experts. But also in other areas, as I just mentioned, with regards to product safety and product liability authorities, they're also already looking into how those regulations apply to AI. AI being just a technology, but it's more important to look at how AI is being deployed in a specific use cases. And Chris, at the very start of our call, Kathryn mentioned that Italy now has a draft law, has a law on the AI. Well, draft, I'm saying draft because it's not applying yet, but and that law specifically has provisions, for example, on using AI in employment that go over what's said in the AI Act, and specifically sets out principles that need to be taken into account when deploying AI in the workplace, what information employers need to provide to their employees with regards to the use of AI, the work representations, what information they need to get, but also, for example, for lawyers, if they're using AI, they need to disclose it to their clients. So there are all these obligations on the use of AI, which are very, going into the sectorial laws, right? Then we also see in the financial services sector, there is recent laws on, like, if you're using AI, for example, for automated decision making, what rights do individuals have when their credit rating is determined that way? Can they appeal those decisions? Can they ask for human intervention? All that. So there's really a regulation coming up in so many different sectors, and that regulation often is not really specific for AI, but it's just to make the laws more digital here in Europe. So digitalizing the laws, and then sometimes there's like one provision that's more specific to AI, but there's just a general trend of digitalization in Europe. And with regards to your question, Alexandra, quickly on like what's happening with regards to the AI Act in terms of like whether it will apply or not. Well, just last week you had different statements coming out. You had one, that in July the Commission said we're not going to delay the AI, but at the same time now the Commission has come up with a public consultation on the digital omnibus, which among others looks into amending the AI Act, right? And they want to have proposals in the books in the next year, something really quick. So clearly, okay, they're not going to delay it, but they're thinking about amending it. And one of the amendments could be potentially delaying the enforcement of some of its provisions. So delayment is still in there. And at the same time, you had also influential people such as Mario Draghi, which is former president of the European Central Bank, but also former Prime Minister of Italy, who is very influential here in Europe right now because he drafted a report that's the basis for simplification, coming up still, I think, was it earlier this week, earlier this week or end of last week, saying, hold on, don't amend the act so quickly without seeing what are the drawbacks. And then you also have two very influential members of the European Parliament who were really at the core of drafting the AI Act, saying, should you actually be amending the AI Act? Isn't it good as it is? We still have some time to put in place standards. So are you not making a mistake amending it without making a proper assessment of like what's now the impact of amending it? Because if you're talking about the mistakes of adopting it, maybe the mistakes of now amending it will be greater than the mistakes of adopting it. So there's all this discussion going on, and I think we're really at a moment where we don't know what will happen. I don't think anyone knows right now what will happen.
Oh, so we need to keep posted from what I understand. One of the attendants asked the question, and I believe you already started answering, but I'll just throw it out there. Is it possible to envision that an universal approach, like an international universal approach, for instance, by the United Nations, Yeah, are regulated by international bodies like the UN. What do you think about that?
I'm happy to take an initial stab. I'm sure you guys also have stuff to say on this, but I think that it's something that sounds nice in theory, but it really underestimates the complexity of AI and the variation within the space. And I think we've referenced a couple of times during this session the fact that AI, you can't really refer to AI as one thing within a regulatory context, because there are a lot of different technologies that we're actually referring to when we talk about AI. And there are also a lot of different applications that we're referring to when we talk about AI. And then when you add to the mix the fact that AI is constantly developing and we're seeing new emerging capabilities on the horizon, it gets even more complicated. And right now you're seeing a lot of discussion about agentic AI and what that's going to mean, especially from a legal perspective. I'm sure you have thought a lot about that, Anna Sophia. But I think thinking about AI as something that is even possible to regulate universally is a little bit of a problematic perspective to come into the debate with. And so I think what is more feasible is thinking universally about what are the norms that we want to see and the outcomes that we want to see out of AI regulation. And that's where I think it's really important to think about AI as something that is cross-cutting across many, many different issues in society. Like I said, many different applications, many different places where it comes into play. And so I think from an international perspective and from a coordination perspective, it's a lot more straightforward to think about, here are the outcomes that we want to see. Here are the outcomes that we don't want to see. Here are the concerns from a safety or fairness or equity perspective that we want societies around the world to be considering. Another thing that organizations or international bodies could consider would be specific methodologies for regulation. There's a lot of conversation about kind of innovative approaches to regulating AI. So you have a lot of conversation about flexible regulation or adaptive regulation that is supposed to change over time, and it is explicitly designed to work with a constantly adapting, a constantly evolving technology like AI. You also have conversations about, just adapting existing tort and liability law or using insurance. And I think thinking more comprehensively about the levers and the tools that are available to policymakers is another useful approach that international bodies could take. Even if we can't necessarily get to like a complete universal regulatory regime.
Yeah, that is very interesting. So can you tell me just a bit more elaborate about the flexible regulation, if you don't mind?
Sure. One example that I can cite is that there was a researcher, I unfortunately can't remember the name right now, out of University of Pennsylvania, who had a proposal for AI leashes as opposed to AI guardrails. And so we talk a lot about AI guardrails as kind of lines that we don't want AI to cross. So AI in the training phases will be kind of instructed not to make particular statements or assumptions, and kind of you work in the barrier against safety issues that way. The leashes approach would be, instead of taking that ex ante approach, we take an ex post approach where we're constantly evaluating AI's use. You have a human in the loop, and the goal is to kind of constantly be tweaking the AI and adapting it rather than trying to predict all of the risks from the outset. But it's an interesting paper. I'm happy to send it along if you'd like to link it in the chat.
I already put it in the chat, by the way. So to our attendees, please, you can find the paper. Thank you so much. Christabel, you want to add something on this?
I think that's an interesting question. I think because everyone is talking about it, I can understand the appeal of wondering whether UN can regulate, but also we have to understand that the first thing is that AI governance and AI norms, and I completely agree with Giulia that the purpose of these global forums is to drive consensus on norms, approaches, safeguards. It's not necessarily to regulate, because it is a forum of sovereign states, and sovereign states will enact their own laws and enforce them. But the issue of what are these norms are not new. It goes back several years. It goes back to when we talk about transparency, explainability, accountability, safety, security. These are not new. These are very old. People have been working on AI since the 1950s. And these norms, whether you think about them as legal norms or whether you think about it as technical approaches, have been around for a long time. And we see these reflected in the EU AI Act, which is now binding. We see it reflected in the OECD AI principles. We see it reflected in the UNESCO recommendation on AI ethics, which, by the way, has been adopted by 193 countries. So that really reflects the global consensus. And we also see it in the Council of Europe's Treaty on human rights, fundamental rights, democratic institutions, and rule of law. And that treaty is, which is going to be the first binding treaty on AI, is most, hopefully 40 countries ratify it, and it goes into effect this year. So in terms of whether there is global consensus, absolutely. Now, how that should be enforced from country to country is where we see different approaches, because different countries have different priorities, they have different innovation capacity, they have different stages of market maturity, and they also have different stages of enforcement agility. But the flexible approach, the only thing that I would caution between norms and flexible regulation is, I absolutely agree that the technical regulation, the technical standards. So, for example, if we have an AI auditing standard, what should that AI auditing standard look like? That can evolve as the technology develops. Or if we have cybersecurity standards, for all this time it was for automated decision-making systems or the more predictive narrow AI. But now when we talk about cybersecurity systems for what is more probabilistic general purpose AI, that might look different, and those technical standards can differ. But what should not, but that should not, again, undo a lot of the good work in terms of the legal norms. So for example, if it doesn't matter what technical standard or technical regulation you follow, whether you do it ex ante or ex post, but for example, if there is a safety issue, if there is a consumer risk issue, that accountability should not wait for the fact about whether there is the technical standard has been adapted or not. So I think in terms of understanding norms, the EU AI Act talks about transparency. Even the current Trump administration's AI action plan talks about transparency. The AI action plan was accompanied by 3 executive orders. And while the names or the titles of the executive orders might cause some confusion. So for example, there's one executive order saying preventing woke AI in federal government, right? Now, it sounds like a very political executive order, but if you go and look at the provisions, it talks about the fact that large language models must be accurate, must be reliable, must be scientifically valid if you want to procure them and deploy them in the federal government. So a lot of this is also, cutting out the politics and the rhetoric and really looking at both the important policy actions and the norms around which there's already consensus.
Thank you so much, Christabel. I'm always reassured when I listen to you. It feels like everything will be all right. Can I give you the floor to elaborate? I see that a attendee asked you a question and you very kindly answered. If you want to share with everyone. And then I just wanted to give it a heads up. There is an attendee, Mariam Baksh, when I'm going to give you just afterwards, I'm going to give you the floor. If you can please summarize your questions, because so that we could answer them. Okay, Christabel, if you wanna share with everyone the question and the response.
Yeah, so the question was about the call for red lines, right? And red lines can be seen in two different contexts. So one, you can see red line in a broader context of about prohibitions on AI systems that have certain serious impacts on human rights. And we already see that reflected in the EU AI Act. For example, it says you cannot use an AI system to do social scoring. You cannot use an AI system to do remote biometric categorization unless some very narrow purposes for, law enforcement. And then we see red lines in a more long-term perspective, in the sense that should we have AI systems that are integrated with autonomous weapons, lethal autonomous weapons? Should we see AI integrated or developed in a manner that creates huge bioweapon and biosecurity risks? The Center for AI and Digital Policy, we call the red line, we've called it the termination obligation in the Universal Guidelines for AI, which was not really by any government body. This was just a consensus framework developed by a lot of practitioners and experts, and then actually got replicated or got adopted in many binding frameworks that we just talked about. But the red lines really, and this is where bodies like UN, and we've been talking to the CCW, the Convention on the High Contracted Parties on Conventional Weapons. We've been talking to the United Nations Disarmament Research, also looking at the long-term safety, national security risks. I think it's in everybody's interest if we don't have an autonomous AI system in charge of a nuclear weapon. Right? So that's the Red Lines campaign, and that's the call that we've been involved with for a long time. We made a call last year at the 79th UN General Assembly. This year, we're happy to join with a lot of other partners. Maria Ressa, the Nobel laureate, actually introduced the Red Lines campaign at this year's UN General Assembly. This year, our partner, the Future Society, is actually leading the campaign at this year's UNGA. But this is a very good case of where global consensus can really form some sort of a binding framework, the way we have for nuclear non-proliferation or other conventional weapons.
Thank you so much. Thank you for sharing this. Mariam Bagsh, I'm going to give you the floor. If you can summarize your questions to our panelists, please. You're on mute.
Hear me now?
Yeah, we can hear you.
Awesome. Thank you so much. I guess my question, to broaden it out a little bit, is to suss out where you guys might be seeing, if at all, any sort of shifting around how the word safety is applied in AI regulatory conversations, either domestically or internationally. I'm asking this because, as you guys know, or I expect, AI safety is very closely associated with AI alignment and this sort of addressing existential risk, such as the AI becoming sort of self-aware and taking over systems and launching a nuclear weapon, just to bring it back to what Christabel was just saying. But, this sort of X risk, right, which is very closely tied with misuse as well. And then, the expert from the EU is talking about product safety and the relationship with product liability, which came up in character AI's defense and Google's defense in the lawsuit where the chatbot was involved in alleged wrongful death of teenagers. So Google's defense being, or the AI company's defense being collectively, you know, we can't be liable for product liability because we're not products. We don't make products. So I'm just this is supposed to be a summary, but I think I ended up elaborating on my question.
Yeah, we don't have too much time, so we'll
just
try
do you see
to
a
wrap it
shift?
up here. Yeah.
Do you see a shift in the way that safety is being used, and or maybe address how important that would be to shift from this previous association with X risk to now sort of the product liability space?
Thank you, Miriam.
I'm happy to take a stab at it. I think if you go to any of the marketing pages of all of these AI companies, they describe them as products. So I don't think you should have the benefit of selling products and then when you face liability, say, oops, I'm not a product, I'm a service. But we see this playbook being used by the tech industry a lot in the US, where especially since the First Amendment offers certain protections, and that has been very, very widely interpreted to offer some kind of a liability shield in the context of social media. And we see that, being replicated in the context of AI. But if you are marketing it as a product, I think that's the first thing. And that's also something that we relied on when we filed a complaint to the Federal Trade Commission. Increasingly, courts are also looking at these as products. The Congress, in its recent congressional hearings on the Senate Judiciary Committee hearing on AI chatbots, referred to them as products and also went so far to say that they are defective products. So yes, there is a lot of framing and naming, both industry-driven, amplified by media, amplified by, a lot of different voices. But I think and I'm a pragmatist as a person in this space, if saying safety gets to the outcome where you have more protections for consumers, whether it's from nuclear weapons or whether it's from chatbots that are harming children, then call it safety. If saying fairness in a different time and space works better, call it fairness. The point is to have some guardrails in place to make sure that the technology is delivering more good than bad outcomes.
Thank you so much, Christabel. Thank you very much. And I am very mindful of the time. And once again, I just want to all thank you for joining today. I just want to make like a round of the table with you ladies today, and just to give me the key takeaways of our conversation. If we need to put the essential key takeaways today, what is your final word? Sophia, you want to start?
Sure. So from your perspective, key takeaways are there is a law, and likely that this law will go away. There might be some changes to it, but I don't think business should expect too much of those changes. And what's also the point is that that's just one law. There's so many other laws in Europe ensuring the safety of products. And just as the question came, laws are being changed so that they become more digital and would apply to AI. The general product liability law was changed so that it specifically applies to AI. So the key message being there are several laws in the EU that apply to AI. AI is one of them, and they're here to stay, and they're unlikely to curb AI innovation as a whole because they're actually quite specific as to what AI uses and systems they apply to. So just make sure that whenever you are wanting to operate in the EU, whatever uses you want to have, you check, are they covered by existing laws, and to what extent do I need to comply? Because it all may sound very scary, but whatever your AI use specifically may not be covered, or it may be covered by these other laws and not the AI Act. So don't be scared by the fact that there's a EU AI law.
Thank you. That's a good one. Giulia?
Sure. I think the main thing, and I'm sure Christabel will elaborate on this as well, is that there is already a lot of existing regulation around AI. And I think that in the US context, it's important to consider that while we may not see a comprehensive approach to safety or fairness regulation anytime soon, there is still a lot of work that's being done, particularly on the state level and also on the level of kind of establishing norms and thinking about other voluntary mechanisms that might be able to kind of fill that gap. And so I would encourage people who are interested in that space to do, some thinking about the AI technology itself, because I think that understanding the parameters of the technology is really important for understanding what regulatory levers and mechanisms are actually available.
Thank you so much. Very interesting. Christabel?
I think I'll conclude with an example. So we have Anne-Sophie here on the call, who is a fantastic lawyer from EU. Imagine if Anne-Sophie, you went to Anne-Sophie, you paid her 500 euros and you asked her for an opinion, and it turns out the opinion was wrong. And then Anne-Sophia says, oh, sorry, I hallucinated, right? You wouldn't accept that. Now you go to a chatbot, you type into ChatGPT or Claude or Llama, whatever, asking for a legal opinion or medical advice. You're not paying 500 euros, you're probably paying $20 if you have a subscription, but it's completely wrong, and it's because the chatbot hallucinates. Would you, if you don't accept it from a human, why would you accept it from the technology? And I think this is a very common sense approach. Hallucinations are not a problem. It's not a sometimes issue with this. It is a feature. So that means because of the way it is designed, it will hallucinate. And I think we want innovation, but I think we want innovation that is we should demand better, both of our regulators and our innovators. We're consumers, we pay the price, and that's what we should ask for.
Thank you, Christabel. We cannot wrap it up better. Thank you all for joining us today. We are only 1 minute over. I feel like this conversation merits to be continued. So maybe we'll do like a follow-up next year and see what's around. Thank you. Bye. Bye-bye.
Thank you, everyone.
Thank you for having me. Bye.